Yes, students, I'm going to dictate a passage relating to shorthand, that is 100 words per minute. 5 seconds. Start. The present writ petition is filed by the corporation, agreed by the award dated 24/9/2007 in ID number 113 of 2004 of the respondent Industrial Tribunal, which modified the order of removal dated 19/5/2004 passed by the disciplinary authority of the corporation to that of compulsory retirement from service. The facts in brief are that the first respondent joined the service of the respondent corporation on 1/4/1978 and got promoted as mechanic in the year 1979. When he had been continuing in the service, he was charge sheeted on 14/12/2003 with an allegation that on 14/4/2003 the security guard of the depot found some material kept underneath the driver's seat, ostensibly by the petitioner. Accordingly, in response to the charges on 7/1/2004, the first respondent submitted his explanation. Not satisfied with the explanation submitted by the petitioner, the corporation went ahead and conducted a departmental inquiry which resulted in removal of the petitioner from service through orders dated 19/5/2004. Though the first respondent carried the matter in an intra-departmental appeal, it was also dismissed on 26/7/2004. Even the revision preferred by the first respondent was dismissed on 15/2/2005. Eventually, the first respondent raised an industrial dispute before the Industrial Tribunal in ID number 133 of 2005. On appreciation of the material on record, the Tribunal has held that the punishment imposed on the first respondent by way of removal from service by the disciplinary authority is shockingly disproportionate and has accordingly modified the same to that of compulsory retirement through award dated 24/9/2007. Aggrieved thereby, the corporation has filed the present writ petition. Initially, stay was granted by this court through an order dated 11/7/2008, observing whether the tribunal has got power to order compulsory retirement in the place of removal from service by way of modification of punishment. Subsequently, when the first respondent filed a petition to have the order of stay vacated through an order dated 26/3/2009, this court has observed that the matter is required to be heard finally, and as such, the vacate petition was dismissed. The first respondent filed counter denying the averments made in the petition. It is pleaded that the very order of tribunal itself is unsustainable and it ought to have been complete reinstatement. Even on the part of the petitioner corporation, the inquiry was totally lopsided and the issue had not been properly appreciated either at the stage of domestic inquiry or during the course of the proceedings before the tribunal. Eventually, first respondent has pleaded that it is he who has been aggrieved by the award but not the petitioner corporation. The Land Standing Council for the petitioner corporation has strenuously contended that the allegation is grave in nature since first respondent was charged with the offence of theft, which is more than a mere misconduct. According to the Land Standing Council, charges have been framed and due to opportunity was given to the first respondent to put forth his defense. That apart, the first respondent participated in the inquiry and had ample opportunity to counter the charges leveled against him. Stop. Yes, students, I am going to dictate a passage relating to shorthand.